Why is a Supreme Court decision in MetLife versus Glenn so important to the rights of disabled claimants? Hi, I'm Mark Whitehead, a board-certified disability insurance lawyer. In Metropolitan Life versus Glenn, a Sears employee named Wanda Glenn suffered a disabling heart condition in 2000. Glenn applied for LTD benefits under Sears Employee Benefits Plan through MetLife. MetLife had both the discretionary authority to determine whether Glenn's case was valid and to act as the payor of benefits. MetLife initially determined that Glenn couldn't perform the duties of her own job and granted Glenn a 24-month disability benefit. MetLife also told Glenn to apply for Social Security disability benefits. In 2002, Glenn was found by the Social Security Administration to not only be disabled from her own job, but to also be disabled from any job for which she was reasonably qualified. Glenn was awarded permanent disability payments by the Social Security Administration for her disability claim, retroactive to April of 2000. 3/4 of the Social Security benefits went to MetLife as an offset rather than to Glenn. The rest went to attorney's fees. Glenn then applied to MetLife for long-term disability benefits and was denied by MetLife. MetLife said that her condition had improved to the point that she was no longer totally disabled, even though the Social Security Administration found Glenn to be totally disabled. Glenn challenged the MetLife disability claims denial in federal court. MetLife, however, fought back, arguing that it was entitled to a discretionary standard of review, as MetLife was entitled to discretion in making benefit determinations. The federal district court reviewed the administrative record and upheld MetLife's denial of benefits. It found that abuse of discretion was the correct standard of review and that MetLife had not abused this discretion. Glenn then appealed to the U.S. Court of Appeals for the Sixth Circuit. The Sixth Circuit reversed the decision. The Sixth Circuit Court of Appeals concluded that MetLife had a conflict of interest, as MetLife both decided the claim and paid the claim, and that this conflict was a relevant factor in determining whether MetLife abused its discretion. They also factored in other serious concerns, including MetLife's failure to consider the Social Security Administration's determination that Glenn was totally disabled. In June of 2008, the Supreme Court ruled against MetLife and in favor of Mrs. Glenn and upheld the Sixth Circuit decision. The court's overturning of MetLife's disability claims denial in this case may improve the standards for review in ERISA disability claims and positively affect the future of ERISA litigation. Conflict of interest will be given proper weight as a factor in determining whether an insurance company abused its discretion if it denies a claim. With or without new Supreme Court decisions, an in-depth understanding of ERISA law and the insurance industry is paramount when dealing with unfair disability denials. This topic is discussed more in my free ebook, Long-Term Disability Insurance Policies: How to Unravel the Mystery and Prove Your Claim. Visit www.disabilitydenials.com for a free downloadable copy, or call 1-800-562-9830 to discuss your particular disability insurance issue. I'm Mark Whitehead. Thanks for watching.